Welcome to The Explainer. Today, we're jumping into a case that is absolutely essential for any aspiring Australian barrister. Seriously, if you need to get evidence to prove your case, you need to know Evans Deakin versus Orekinetics. All right, so let's set the scene. Imagine this lands on your desk. Your client is convinced, absolutely positive, that their trade secrets have been ripped off by a couple of ex-employees. These guys have started a rival company and are already advertising some newfangled machine that just seems way too advanced to have been developed so fast. You know you have to see what's inside that machine. So what do? How do you get a judge to sign an order that lets you walk into their factory? Well, this is your primary weapon, your go-to. It's Rule 250 of the Uniform Civil Procedure Rules. You need to know this one. It basically gives the court the power to say, yep, you can go inspect that property, as long as it's central to the case or seeing it is necessary to figure out a key issue. It's a really direct and powerful tool in your litigation arsenal. But, of course, it's not a blank check. Using this power puts the court in a really tough spot. It's a classic legal tightrope walk. On one side, you have the need for justice. You have to let a plaintiff get the evidence to prove their case. But on the other, you have to protect the defendant from what lawyers call a fishing expedition, just a random, baseless rummage through their private business and their own trade secrets. And this exact dilemma, this perfect balancing act, was right at the heart of the landmark Queensland Supreme Court case, Evans Deakin versus Orekinetics. This case is the perfect story to show how a court thinks this through. So let's meet the players. On one side, we have Evans Deakin, the established engineering company. And on the other side, well, you've got two key guys who just left them, the research manager and a draftsman. And they've immediately set up a competing company called Orekinetics. Sound familiar? It's a classic IP dispute setup. And this is where it gets really interesting. The timeline is, well, let's just say it raises a few eyebrows. The manager quits on February 5th. Less than a week later, Orekinetics exists. Then, just over a month later, over a 3-day span, he files 3 complex patents. This wasn't some slow, methodical development. This was an absolute explosion of activity. And then, you couldn't make this up. The defendants pretty much hand Evans Deakin their best piece of evidence. In their own brochure, they boast about a revolutionary new machine that they've recently developed. You can almost hear the lawyers for Evans Deakin asking the obvious question. How on earth do you develop something so revolutionary, so recently, without taking something with you from your old job? So, with all that in hand, Evans Deakin marched into court and asked for an inspection order under Rule 250. This forced the judge, Justice Chesterman, to do a deep dive into more than 100 years of legal history to figure out what the right test should actually be. So it goes back and looks at the old cases. You had these really strict old-school tests from the 1880s, saying mere suspicion is not going to cut it. He saw the very real concern about fishing expeditions. But what really caught his eye was a more modern, more flexible English case, British Excellonite, which said, hey, if there's a substantial and genuine issue here, we should allow an inspection. You can see the legal thinking evolving. And this brings us right to the money shot. This is where Justice Chesterman takes all that history and forges it into the modern rule we use today. This is the key takeaway from the whole case. He just cuts through all the old, confusing language, mere suspicion, strong suspicion, all of that. He says the real question, the only question, is this. Looking at everything, all the circumstances, has the plaintiff shown sufficient grounds to justify going onto the defendant's property? That right there became the definitive test in Australia. So what does that actually mean, sufficient grounds? Here's the most important part. You do not have to prove your entire case just to get a look inside. You just need to give the judge enough. Enough to make them think, okay, yeah, given the ex-employees, that crazy timeline, and those marketing claims, an inspection seems like a pretty reasonable next step here. It's a common sense standard. And he grounded the whole thing in a really practical idea. He pointed out that Rule 250 isn't just there to help one side win. It's there to make the whole process of litigation smarter, faster, and cheaper. You know, getting an early look can clear things up, focus the real issues, and save everybody a ton of time and money down the road. So, let's bring it all together. What does this mean for you, whether you're studying for the bar exam or you're about to stand up in court for your first interlocutory application? Simple. This case gives you the playbook. This is your checklist. First, you tell the story. Lay out all the facts. Second, you hammer that suspicious timeline. Third, you point to all the red flags, like those crazy patent applications. Fourth, and this is key, you argue this isn't a fishing trip, it's about making the case more efficient for everyone. And finally, a real pro move. You offer safeguards. You tell the judge you're happy to sign confidentiality undertakings to protect the defendant's legitimate secrets. It shows you're being reasonable. Look, for your exams and for your entire career, if there's one case name you highlight in your notes on this topic, it's this one. Evans Deakin is the go-to authority. It's the one you cite, full stop. Because after wading through a century of law, the court boiled it all down to one clear, powerful guiding principle. It all comes down to a single question. Have you shown sufficient grounds? And that leaves us with the final thought. In this case, yes, the court granted the inspection, but the test is only as good as the facts you bring to the table. Evans Deakin gives you the rule book, but knowing how to use it to actually win, well, that's where a barrister truly earns their robes.